A warm welcome, ladies and gentlemen. I'm Steve Smith, Vice-Chancellor of the University of Exeter. I would like to apologise for one obvious thing, which we, although we've got the meteorological office in Exeter, we didn't anticipate, and nor more importantly did our hosts here at the British Embassy, the heat wave. And as of course some of you know, heating systems get turned on and off. So as of the 15th of August, heating is on, and as you may have noticed, air conditioning is off. I apologise, we've had someone here trying to sort it out, but there's not much we can do. We've got a fan up there blasting a bit of air, but that tends to be hot air. Although hopefully tonight we won't actually get much more hot air. But what I would say is, colleagues, if individuals wish to take off layers of clothing, I'm not going to go very far in this analogy, but if you want to take jackets off, please feel free. We'll leave the doors open, and hopefully it's okay. Look, can I just thank each and every one of you for coming here this evening. It's great to be here in Washington DC, third time universities put on an event here in recent years, and it's this wonderful venue here at the British Embassy. So I'd just like to say a few very quick thank yous if I may. I'd like to thank everyone for coming this evening. It's great to see so many corporate and university partners alongside our growing cohort of Exeter alumni resident here in the States. We're very proud actually to have more than 2,000 alumni here in the USA. I'd like particularly to thank the University of Exeter US Foundation, which is established in 2014 and allows alumni and friends of Exeter living in the US to raise funds for the university and to continue to be active and important members of the community. We're incredibly lucky to have an outstanding group of dedicated alumni that have taken on the roles of directors of the board, and I'm delighted that most of them are here this evening. The directors are Graham Hill, Susan Alderton, Jonathan O'Brien, Charles Platt, Howard Appleby and Dominic Caprani. I'd like to thank them all for their support for this institution. I'd also like to thank the Journal of Law and Cyberwarfare for helping to promote this evening's conversation, and of course the staff, especially the heating staff, of the British Embassy for their assistance in hosting us this evening. And last and absolutely not least, I really want to thank our speakers and contributors this evening. First, Professor Schmitt, Professor of Public International Law at the University of Exeter, and secondly, Tom Wingfield, Professor of Cyber Law at the National Defence University here in DC. Professors Schmitt and Wingfield will be sharing their research findings with us, focusing on the crucial question of whether international law governs activities and behaviours in cyberspace, and if so, how. We'll then take questions from the audience, chaired by Professor Janice Kay, Provost at the University of Exeter. So, before we begin, just a few words about Global Conversations. These events are designed to showcase how research at the University of Exeter, working in collaboration with our partners across the world, is having a global impact. This is the third global conversation we've held in the US. A year ago we were in New York demonstrating the impact of the 300 staff at Exeter who work in climate change, and then an event in San Francisco explaining how our staff are pioneering new discoveries in the causes and treatment of dementia. So why do we collaborate and showcase our work? It's really simple. There's no one country or university that has the resource to solve all alone the world's emerging challenges, such as cybersecurity. All the evidence shows that international collaboration in research has much greater impact than research produced in one country. It's more highly cited than that which is produced solely within countries, and its conclusions are more influential in our global and interconnected society. I hope that this evening's discussion will not only give you an insight into the latest research of Exeter faculty, working often with our eminent partners here in the US, but also how we can tackle shared problems together. The University of Exeter is very well placed indeed to help lead such debates. We are a top 10 UK university, and we're also ranked in the top 1% of the main world rankings. And in the latest Leiden ranking of universities, which only looks at the quality of research, we're ranked 35th in the world. We're one of the fastest growing universities in the UK in research, and we think therefore that we can help answer some of the pressing problems humanity faces. So we're committed at Exeter to ensuring that the teaching and research that we conduct is preserved and enhanced, We want to continue to recruit the very best students and the best faculty globally to improve continually our performance in research, innovation and impact, and crucially, working with international governments and industry to play our part in finding solutions for some of the world's shared challenges. We really do this in genuine partnership and collaboration with thought leaders across the world, and in particular, colleagues here in the United States. Global Conversations, you see, is about advancing the debate together. I hope you enjoy your evening. I'd now like to hand over to our first speaker this evening, Professor Michael Schmitt. Michael.
So, I'm from South Texas. I'm not too sure what all the whining about the heat is. But I'm taking my jacket off just to feel comfortable, okay? What I thought I would come here and talk to you today about is the role of international law in cyber warfare. This is really a discussion about research that's been going on for the last 7.5 years, and we'll probably conclude about in January. Let me tell you what we've done. We have engaged in a process, an international process sponsored by a NATO entity called the Tallinn process. As I mentioned, that's gone on for 7.5 years. What I'd like to do tonight is tell you about what we did, tell you about our research that we've been engaging in, and then I'd like to turn to the topics that capture the imagination of states most frequently with regard to cyber operations and international law. Now, where did it all start? It actually all started in Newport, Rhode Island at the Naval War College. This was the first place where law in the context of cyber was ever considered. There was a conference in the late 90s to address the issue of law with respect to cyber warfare because we were concerned that the cyber warriors were getting out ahead of us. They were building cyber capabilities before they knew what the rules of the game were. So we started a project at the Naval War College that ran for a couple of years, and then 9/11 happened. And all the international lawyers that were focusing on cyber law, every single one of them quit focusing on cyber law. They started looking at counterterrorism, detention, kinetic operations in Afghanistan and Iraq and so forth. So there was a big burst of energy. In fact, Tom, who will follow me, was one of the pioneers. He wrote an early, very good book on the subject. There was a big burst of energy. 9/11 happens. All the international lawyers turned their focus elsewhere. And then in 2007, this happened. This was Estonia. It's a very interesting story. Estonia had been an independent country after the First World War. It gained its independence. However, during the Second World War, it lost its independence. The Soviets came in, made Estonia a republic, part of the Soviet Union, and essentially, as a matter of law, occupied the country for decades. Well, as you know, eventually many countries in Eastern Europe gained their independence, if you will, and part of the old Soviet Union, the former Soviet Union. Some of the republics, like Estonia, like Latvia, like Lithuania, gained their independence, and they were delighted. But what they weren't delighted about was in the middle of Tallinn, which is the capital of Estonia, there was a statue, like there was in every Soviet city. There was a statue to the Great Patriotic War. This was called the Bronze Soldier. So the Estonians are thinking, well, it wasn't so great and it wasn't so patriotic for us because we were an independent country and then we lost our independence. So let's move that statue. And so they decided to move this statue, the Bronze Soldier, to a cemetery just outside city limits. When that happened, the ethnic Russians in the country, about 23% of the population, went nuts. They were extraordinarily upset because for them, it really was the Great Patriotic War, and this was moving their statue commemorating their loss and their victories away from the city center. So they rioted in the street. And they rioted because online they were encouraged to riot. And then, as they were rioting in the streets, massive cyber attacks were launched against Estonia. Both government and commercial interests. Basically, it shut the country down because Estonia had become super wired. And the reason is because it was so badly broken when it came out of the Soviet Union. So countries like Sweden, and Denmark, and Germany went into this broken country and wired the country. As a consequence, in 2007, when the cyber attacks start, the country shuts down. Now, there's some question about who was behind the attacks. 177 countries, Cyber forensics tells us they were launched from 177 countries, mostly from Russia, but many other countries. There was some indication that Russian government cyber infrastructure may have been involved, but they're not certain if the Russian government was behind it or someone was taking control of that cyber infrastructure to launch against Estonia. Now, this was really traumatic for the West. And the reason it was traumatic for the West is because by this time Estonia had become part of NATO. And the Estonians said, well, hey, we're a member of this alliance, and this alliance is all about collective defense, and it sure seems like we're being attacked from Russia, so let's go to NATO and let's get us some of that NATO help. But of course at NATO, they panicked when the Estonians came forward. Now there wasn't a formal request made, but there was some initial, we're thinking about invoking Article 5 of the treaty. They panicked because the last thing they wanted was a war with Russia over a tiny little country that has almost exactly the same number of people as Rhode Island, while they were also involved in conflicts in Afghanistan and Iraq. Eventually, it died out. After about 10 days, things started to resume normalcy. There was a lot of assistance from the West to get them up and running. And so that event faded away, but that event caught us cold, the international lawyers. Because what happened is, as the attacks are happening, people were asking the international lawyers, so what's happening? Is that an attack under international law? Can we respond kinetically? Does NATO really have to come to the assistance? And we didn't know any of the answers. Now that sort of activity has continued, if you read the newspaper, to this very day. The very next year there's a kinetic conflict between Georgia and Russia in which there were lots of cyber attacks against Georgia. Stuxnet, you know about, operations against Iranian centrifuges. The Iranians brought down an American drone, it seems like. There was the Sony hack in which the North Koreans are hacking into a private company in the United States. OPM, the Office of Personnel Management. If you work for the US government, the Chinese know all about you, they know all about me, and they know all about Tom Wingfield. Gary Brown, they know all about, they know all of our secrets. And then, of course, the Russians appear to be actively involved in our election. Okay, so it's still going on and on and on. It's lots of interest. The problem is, what's the law? When it all began, cyberspace was considered like a wild west where there was no law at all. NATO decided through an organization called the Cooperative Cyber Defence Centre of Excellence based in Tallinn, NATO decided to take a look at the law that governs cyber operations. So what they did is they gave us money for 3 years, a 3-year project. An international group of experts convened. A number of them are in the group. Tom was originally the director of the group, co-director of the group, but he got called by the nation to go to Afghanistan, and so he was out of play for a little bit. Gary Brown, who's in the audience, was then a colonel in the United States Air Force, and he was the legal advisor for United States Cyber Command, and they were observers in the process. So there was this international group that was given 3 years to produce something on the law of cyber warfare, and that something is this book, the Tallinn Manual. So that's what I'll be talking to you about today. I would say that although a number of us were working for the government at the time, I was a Department of Defense employee, for example, the views, and we had the Canadian Judge Advocate General, we had the Australian Chief of International Law for the Australian Defence Forces and so forth. Despite the fact that lots of us worked for government, it was very clear that the project was only to set forth our views, because governments were extraordinarily nervous about this project. They were worried that these 20 academics in a country they'd never heard of were going to do something, write a book, and it would be the only book in the land of the blind, the one-eyed man's king. So they were very worried about this project. What would these academics say? And would we somehow, we, the states, somehow find ourselves bound by their conclusions? We'll talk about that in a moment. What did the project cover? Well, like all projects, it starts small and gets bigger and bigger. We were only looking at cyber war in the beginning. But then it quickly expanded to the question of uses of force between states. So we started with war. Who can you shoot at? What weapons can you use? Those kind of questions. What if it bleeds over into the civilian infrastructure? What's the law that governs that? We then expanded a little bit to use of force questions. In fact, Tom was our expert in that. And we were looking at if country A conducts a cyber operation during peacetime against country B, what's that mean? Is that an armed conflict and so forth? So Tom looked at that, and then we met. Even though states didn't want to be involved because they were afraid of being seen to be involved. In fact, behind the scenes, let me assure you, lots of states were talking to us. What are you guys going to come up with on this? What about this? Have you thought about that? One of the senior people is legal advisor at the FCO, Sir Daniel Bethlehem. I met with him, not secretly, I actually went to the ministry to meet with Daniel. And he said something that was very, very important. It would dramatically change the nature of the project. Daniel said, as he looked, he says, it's a great work, but let me tell you what, if in life all you have is a hammer, every single problem is a nail. And he said, if you write a manual about cyber warfare, and that's the only thing in the shelf, the next time there's a cyber attack from another country, you will be thinking of it in the context of warfare. You'll think of it as the rules of war apply. And that's not always the case. In fact, it's almost never the case. Because most cyber operations aren't subject to the law of war. They occur during peacetime. So based on Sir Daniel's suggestion, we expanded to a few subjects like sovereignty, state responsibility, and jurisdiction. We produced a book. We had 20 experts from a number of countries. The book has, you can't see it, but it has called Black Letter Law. We required unanimity, so we have rules. You may not conduct cyber attacks against civilians. It's not extraordinarily profound, okay? That's a rule. Everyone must agree, and then we have extensive commentary, and that's where all of the analysis comes in. What is an attack in cyberspace as a matter of law? So we produced this book. The reaction was unanticipated and horrible, okay? Because it's just, I mean, we got 20 people scattered around, Tom, myself, Gary, a few others. 17 others. Suddenly this book comes out and we're being interviewed by Der Spiegel and The Guardian. And actually my 20-year-old daughter thought this was pretty cool when Mother Jones interviewed us. She said, yeah, Dad, yeah, pretty cool. My dad's cool, Mother Jones. At any rate, what happened is they kind of misread our book. The reason it was considered so extraordinary was because they didn't read the book in context. I'll give you an example. We said in the book that if a civilian engages in cyber activities against one of the belligerents during an armed conflict, that civilian is now participating in the conflict just as if he or she had picked up a gun, and they're targetable for that time. It's not an extraordinary conclusion. The ICRC is here tonight. They agreed with us on that and so forth. But when the journalists got this, it was, NATO says you may kill hackers. And so there were lots of headlines. We had a lot of that explaining stuff to do for a while. But eventually, everyone calmed down. There were many conferences, articles on the book. I just got back from the British Defence Academy a week ago where we ran a course for the British Armed Forces on cyber. We're at the embassy. We've gone to the FCO and talked about cyber issues a couple of times. So it's kind of settled down. Everyone's interesting. There is some criticism from China and Russia that this was Western. These were Western views. I'm an international lawyer. I'm not so sure I know what Western views are. It's international law. But nevertheless, the book was translated into Chinese by the People's Liberation Army Press. That's a good, they may be critical, but that's a pretty good entity to have publishing your book. And in Russia, because it's Russia, of course it wasn't published legally, but there are many illegal translations on the internet that you can find in Russian. So that was the project. It was over. We all kind of relaxed for about 14 minutes, and then NATO came back to us, the NATO Cyber Center, came back to us and said, that was cool, let's do something else. What do you want to do? And after some consultation, a group of us said, we want to keep going. Because we talked about uses of force and self-defense and rules of war, but what about all that stuff that's happening on a daily basis? We talked about the big things, but what about the little things? What about that? So we formed a new group of experts because we were dealing with a different topic, and we have addressed over the last 3 years these topics. States are heavily involved now. The Dutch Ministry of Foreign Affairs is supporting us and has convened 3 meetings of states where they came to comment on our work. We presented it. They comment on the work in writing, and at the meetings, it includes all the states. The Chinese sent 4 delegates, the Russians sent 2, the Indians sent 7, so there are big meetings held in The Hague about this particular project. We're almost finished. Okay, in fact, at 6 o'clock this morning, I was looking at edits from Cambridge University Press before I climbed on the airplane to come here. Now, that's enough on the Tallinn Manual. It'll be on the street in January if my prayers are answered. It's been a long, tiring process. As we went through this, I thought it would be interesting to tell you about the question that we get asked most often by countries, by nations, all these states that are involved in what's known as the Hague process. And this is the question. Our state is the victim of a cyber operation, a cyber attack, a malicious cyber attack. And we know that criminal law applies because it's happening on our territory. But what else can a country do? When the Russians hack into DMC, what can America do? What's their legal option other than trying to bring people to court for violating our domestic law? And they wanted to know, does it make a difference if it's a state that launched the malicious operation, or alternatively if it's a non-state actor like a terrorist group that launched the operation? So here's how we answered it. We said you have 4 options in such cases. I will tell you what the 4 are. The first is self-defense. The law of self-defense is set forth in Article 51 of the UN Charter, and this is the article. And it's very important in the cyber context, because basically what it says is if you're the victim of an armed attack, then you, or you with other people, other states, may defend yourself. And what do they mean by defend yourself? It means you may use force, which would otherwise be prohibited, in order to defend yourself. Now, this is important because, I'll show you in a minute, because the question is, if we're talking about cyber, if we're talking about electrons instead of bombs, when is a cyber operation an armed attack such that you may respond forcefully to that attack? And respond not only in cyberspace, but kinetically. So if you're the victim of a cyber attack that qualifies as an armed attack, when can you, for example, employ a cruise missile in order to put an end to that cyber attack? And then there is some question about whether or not this self-defense provision applies to attacks by terrorist groups, non-state actors. It is our position, the United States position, that you may respond to armed attacks by non-state actors pursuant to this law. It is also the position of the United Kingdom and most other mainstream countries that think about cyber. So the question for us was, we know there's a law of self-defense. We know you can shoot back kinetically or with electrons. We believe that you can shoot back not only against states that are attacking you, but non-state actors that are attacking you. But all of this depends on whether or not the cyber operation has been an armed attack. Because your right of self-defense only matures when there's been an armed attack. So what's an armed attack in cyberspace? We felt in our discussions that this was a fairly high threshold. Because remember what's happening. They're taking off the gloves. You can send the US Air Force into action in the face of an armed attack. So we felt it was a high threshold, and all the experts could agree on was that if a cyber operation causes significant physical damage, or if it injures people, then that's an armed attack. So for example, the hack against OPM would not be an armed attack that you could resort to that you could respond to in self-defense. Now, the one, I almost said $100 question, but I'll say £100 question because it's the same thing. So you need to have some sensitivity, okay? Because I'm American, I live in America, but Sir Steve pays me in pounds. So if you want someone that's in excruciating pain, you're looking at it right now. So anyways, the big question was, yeah, of course if you conduct a cyber attack and it's causing significant destruction, of course that's an armed attack. Of course your nation can respond. But what if there's not significant destruction, but it's really severe? What if it's shutting down your economic system? This question we could not agree on. We could not agree whether or not that would qualify. I believe the answer is yes, but the group could not come to an agreement. And at the end of the day, this is going to be a political decision. We'll have to see what states do in such cases. Now, what about situations where the cyber operation, the malicious cyber operation, doesn't reach that armed attack threshold? What can you do when it's not quite that severe? There are three options. Here's your first. Your first is to take what lawyers call countermeasures. Many people in the audience have military backgrounds. We're not talking about countermeasures in the classic sense, where you're trying to foil the enemy attack. We're talking about something in law called a countermeasure. And a countermeasure works like this. States sometimes commit what are called internationally wrongful acts. That's a fancy lawyer way of saying they violate international law. For example, and I actually built this slide before the recent operations. For example, if one state is intervening by cyber means into the internal affairs of another state by manipulating elections. Okay, so you all have read the newspaper. What the Russians are doing is they're committing an internationally wrongful act in the form of a prohibited intervention into something that is reserved to the United States. That would be an election. So here we have an internationally wrongful act. If a state commits an internationally wrongful act against you, then what you get to do is employ a countermeasure, which is a response against that internationally wrongful act that would itself be unlawful, except for now, the other guy's broken the law. So you break the law, and I get to break the law in response. So you hack into my systems in a way that violates the law, and I get to do something in cyberspace or not in cyberspace that would violate a legal obligation I owe you. For example, respecting your sovereignty, conducting a hack back. Now, countermeasures are something that at least here in America, certainly the UK as well, that we just discovered. No one really paid much attention to countermeasures until cyber. Because it's the classic answer to the question of, golly, someone's hacking into our stuff. Can we hack back? The answer is yes, if it qualifies as a countermeasure. But there are some limits. First, countermeasures are only available in response to actions by states or by non-state actors that are attributable to states as a matter of law, and I'll explain that in a moment. So they don't apply to a situation where you have, for example, a terrorist group, a hacker group, hacktivists, political hackers that are striking at you. You don't get to do a countermeasure against them. There has to be some state affiliation. Second, no retaliation. This is about getting the other side to knock it off. So you can conduct a countermeasure, but the purpose has to be to force them back into compliance with the law. No such, I've heard about with the DNC hacks, oh, we're considering retaliation. There is no such thing as retaliation as a matter of law. There is a countermeasure. There is no requirement that it be in kind. So if they're hacking against you, you don't have to hack back. You can, for example, close your territorial sea to their warships. They normally would have a right to come through. We say, no, now you don't get a right. Because you hacked against us, violated the law, we're going to do this to you. And there's no requirement to strike only at the attacker. So if their intelligence services are conducting operations against you, you can hack back, for example, against their private entities. You can't violate a legal obligation with third states. Is very important because when you're engaged in cyber operations, they tend to bleed over. And if in the bleeding over, they would, for example, violate the sovereignty of a neighboring state, another state can't do that. You can only do something that's unlawful as against the state that conducted the operation against you. And something Tom's going to talk about, use of force. They can't be, your operation can't be so severe that it qualifies as what's called a use of force. And my friend Tom's going to talk about that. What are the two big breaches of international law that we respond to most often, or we can respond to? The first is sovereignty. When you conduct a cyber operation, you may violate the sovereignty of the state into which you are operating. Certainly you do whenever you cause physical damage. Beyond that, it's not quite clear. Here are questions that we haven't answered. What about if you just put malware into a system and it doesn't cause damage, it's just monitoring? What if you, for example, conduct a distributed denial of service attack and you're shutting down services in the country? That's not causing physical damage, but you can't, the stuff doesn't work. My personal view, and it's only my view, is that if you're conducting cyber operations remotely into another country, and cyber infrastructure in that country is doing things it wasn't intended to do, then you are violating the sovereignty of that country. But this is somewhat controversial. The second prohibition that we place, or the second legal requirement that you see a lot in terms of breaching international law, is a breach of your obligation of due diligence. So the United States has cyber infrastructure on its territory. Lots of people are engaged in cyber activities. We have a legal obligation to ensure that those activities don't harm other states. Okay? This is very important, because if we fail to do that, then another state can take a countermeasure against us. So I've got a legal obligation to ensure that cyber operations do not occur harmful into Turkey. If I fail to police my cyber activities, then you have the right to respond against me for my failure by hacking back, and you'll probably hack back at the people that are attacking you. That's perfectly lawful. And then we have the question that I raised earlier, the question of attribution. I said you may only take countermeasures against states or against non-state actors when their actions are attributable to the state as a matter of law. Here's the law, and basically it means that the non-state actors, the hacker group, a private company, terrorist, what they're doing is they're performing functions for another country that country would normally perform for itself. And the example I have here is we have a hacker group that's trying to identify vulnerabilities in another country, and they're passing those vulnerabilities to the state, and then the state exploits it. The state would be responsible for the actions of the hacker group such that you can now take countermeasures against the state. Direction or control is easier if when the state says, do this. If the state says, do this, and the hackers do it, it's just as if the intelligence organs of the state had done that. Who can conduct countermeasures? We're working with some NATO money, so I went up and I briefed the Secretary General of NATO invited me up to talk to all the ambassadors, an organization called the North Atlantic Council, in closed session. It was very interesting because NATO is all about your country's attack, so the other countries come to your assistance. With respect to countermeasures, it doesn't work like that. There's no such thing as collective countermeasures. So if Belgium is the victim of a cyber attack, the United States may not engage in countermeasures on behalf of Belgium. This came as a big shock to the NATO ambassadors. Moreover, to people that work with private entities, like my friend Daniel Gary back here, if you work with private entities don't get to hack back either. Countries hack back. There is a get out of jail free clause. There's always a good lawyer will always find a way. If the state asks the private entity to act on their behalf in striking back, then that's okay, because that's the state. But some company out there that's taking hits in cyberspace does not get to shoot back. Let me skip that in the interest of time and go to the second option. The second option is rare, but it's super important. It's called the plea of necessity. In many, many cases, you don't know who's attacking you. Or it's a non-state actor. You know it's a non-state actor, a hacktivist group, or you just can't figure it out. You can't attribute it. You kind of think it's the Russians, but you're not so sure. In that case, you can still strike back, violating international law, if the operation is affecting your essential interest in a really bad way. The legal term is grave and imminent, but it means really bad. So, for example, if there are operations in cyberspace that are affecting the security of your nation, if they're affecting the health of your population, even though you don't know who's doing it, because remember, countermeasures are only available against states. Or if you do know, and it's a non-state actor, and that non-state actor has nothing to do with the state, then you may respond, but only if you're not affecting the interest of other states in a bad way. So I'm taking hits. I either know it's a non-state actor, or I don't know who it is. I'm going to strike back. I'm going to hack back. But what I need to be careful about is when I hack back, that I'm not affecting, for example, other states' security interests or their health interests or their economy. So it's a very rare circumstance, but the plea of necessity is important because if it gets really bad and it's not a state, you can still respond. And then finally, you may always respond according to the law. There are lots of things you can do. We're at an FCO facility. You have diplomacy. Let's see how that works. You can go to arbitration. I'm sure that'll work well as well. What you can do is you can do retorsion. This is often forgotten. It's a legal term that refers to taking action that is lawful but unfriendly. And in cyberspace, that's important because all the cyber infrastructure in your country is subject to your sovereignty. So if you want, for example, exclude other states or individuals from using that cyber infrastructure, you can't, because it's on British soil, or it's on American soil, or it's on Bolivian soil. You can take actions that would be lawful but unfriendly, indeed harmful to other countries, but so long as they comply with the law, that's okay. So what's the conclusion before I turn it over to Tom? There are two, okay? The first conclusion is when we started out, we heard all this Wild West stuff. I was talking to one of your colleagues about domains of warfare. They were talking about the fifth domain of warfare. There's land, air, sea, space, and now cyberspace. What we found in our project, and it's been going on 7.5 years now, what we found in our project is the current law applies pretty well. You probably don't need a new treaty to govern cyberspace. Probably not. You may want agreements, but you don't need a new treaty that shapes the legal regime. The current law, if you just sit down, calm down, relax, you can probably apply the current law. You just got to think a little bit. The second thing is some of the current law doesn't work very well, like the armed attack. Listen, so I'm an American citizen, and if some other country starts conducting serious cyber attacks against our economy, okay, and they're not destructive and they're not harmful, I want us to respond. And states will respond. And so what we need to do in cyberspace, we need to pay attention to what states are doing because we may see a slow evolution in the law as states respond to the concerns of their population. And with that, we're going to have a question and answer session right after this.
I can read.
We'll wait, and the provost will do this, and we'll give you the first question. Okay?
I'm going to de-jacket as well, so I'll think of something legal to say as I'm disrobing in front of an audience.
You may want to stop there, Tom.
And then wiring myself up. All right, there we go. And here I am. I'm Tom Wingfield. Thank you for your attention, and we will use the last little bit of O2 remaining in the room to hit one or two fascinating topics slightly more narrowly, but slightly more deeply than Mike was able to do, just to emphasize two fascinating points that he has really concentrated on in the last 20 plus years he's been writing in cyber. So we're going to be regarding Schmitt. We're going to be talking about use of force, and we'll be talking about killer robots. That's Mike on your right. All right. Two questions we're going to look at. One retrospective, one prospective. The first is, what is the most significant legal question Mike has built the framework to answer? We'll take a look at that for about 5 minutes. Then we're going to move forward to, what's the next big thing looming in his future? Something even Mike might not be aware of right now. And we'll see what's coming next in his career. Okay, but first, let's look back and look at this big legal question. When we talk about use of force in cyberspace, and yes, remember we're talking not just about a cube with different facets, we're talking about a dodecahedron, many, many different facets. But if we're just thinking in military terms, we're trying to decide when does that rule set apply. It's really a two-step process. First is qualitatively, generally qualitatively, you want to find out if something is what we call a use of force, as opposed to something that's economic, or political, or diplomatic, or criminal, or corporate, or something else, espionage. And once you've done whatever test you do to figure out that it is in the military thought space, Then the second one is more of a quantitative kind of test, which is how bad is it? Are the scale and effects of this use of force so bad that it looks like an armed attack, like tanks across the border, like a smoking hole in the ground, and we may respond through any mix of cyber or kinetic forces? So it's really this two-step process that's critical. The second step is inherently a case-by-case science of single instances. And of course, states will judge this based on their interests and based on the conditions prevailing at the time. However, there's a great utility in having a common language for the first test. How do we legally categorize something as a use of force so it's in the silo for us to decide it's this bad, or this bad? And that's where Mike made an enormous contribution. He came up with what is now universally called the Schmitt analysis. And what he did is, he wasn't trying to think of what the law should be, the lex ferenda. He was trying to look at what states actually did when they called something a use of force, thereby justifying some other actions. And he and his colleagues, well, almost entirely him at the Naval War College at the time, saw 7 factors. And that if you look at any event, a cyber event, a terrorist event, an invasion by Martians, and you look at these 7 different facets of it, it gives you an idea of whether it's military or something else. That there's a military end of the spectrum for these things and a non-military end. And by looking comprehensively through these seven different windows, you have a principled tool in the language of most of the rest of the world where you can say, we believe this is a use of force for these reasons. Now, I'm not going to go through this all because it would take us all the time remaining to do that, but take a look at these things. Severity. Anybody killed? Anything blown up? Immediacy. Military things happen fast. From the time the enemy is irrevocably committed to the attack to the time the attack is manifest in the real world, the tighter that is, the more military that looks. Directness. Causing cause and effect. Military things have a very tight relationship between this is the cause, that's the effect. The tighter that is, the more likely a use of force. Invasiveness. The more protected the target, the more the violation of that target looks military in its nature. Measurability. We both were, before we were lawyers, we were squadron intelligence officers. Some United States Air Force and some in serious armed forces. And we would both look at targets and we'd be able to do battle damage assessment and decide if we got the target or we had to tell the squadron bubbas to go back for a restrike. You can quantify the damage done to something, and if you can, that makes it look military. Economics, political, other things are less quantifiable. Presumptive legitimacy. A complicated name for a simple idea. If the kinetic analog to that cyber action is presumptively legitimate for that actor to do, then it's probably not going to be considered a use of force. But if it's illegitimate and only a state could do it, or not even a state could do it legitimately, then we might call that more a use of force. And finally, responsibility. The greater degree of state involvement and the greater our confidence of our knowledge of that, the more likely. So here we have 7 things under the Schmitt analysis that let us drill down one more level more deeply to help us decide if something is a use of force or not. And that puts us into the silo, and then UK, US, Bolivia would make their decisions about how bad the scale and effects are from their perspective. Now, one thing to worry about. When you do further research on this, it's the Schmitt analysis. The Schmitt trigger is a term from electrical engineering, and I'm sure there are only a handful of you in the audience. This is gibberish to lawyers, okay? Schmitt analysis, not Schmitt trigger. But when you get the Schmitt analysis, now even at the National Defense University, my school under Admiral Hanby and my boss, C.J. Horn, and in other schools, we're having students sit down and do Schmitt analyses. And to do this, they build these. You know what they're called? Schmitt stacks. There's nothing I can say to that. So this is not a true operational template that you can use to bomb people or not. But intellectually, you can go along the bottom from mere pinging to taking down whole country C2 systems, and you can make decisions about how much of each of these factors is implicated, and you get a general idea of the cumulative level to which it rises. It's not going to be a 3.2 or a 7.8. These are judgment calls in law. But you can say, it's down around in the bottom third, probably not a use of force. Or it's in the top third, probably is. Or it's in the gray area. So your lawyers can say one thing, and their lawyers can say something else. So it's a way of imposing some rigor on an otherwise chaotic legal Wild West. All right, second question, Mike's future. Where do we go from here? Well, if I had to say what the next big thing is going to be, I'd say it's these guys, killer robots. By the way, I direct your attention to the upper right-hand corner, which is my favorite graphic in the whole presentation. Those things really exist. I know they look like a combination of water buffaloes and bumblebees, but DARPA has actually built a couple of these things. They are autonomous robots. They can't kill anybody on purpose. They have not killed anybody accidentally. And they're setting them out into national parks to be able to work autonomously and deal with whatever comes up around. So they go walking around on their 4 to 6 legs and just go on hour-long trips on their own. So if you visit a US national park, you may run across these things, and they will only hurt you if they fall over on you, okay? It's DARPA, it's so far a peaceful experiment. All right, so where does this become dangerous? Artificial intelligence, lethal artificial intelligence, lethal virtual, that is not killer robots, but they're in cyberspace, ones and zeros, autonomous agents. Now what's the difference between automatic, we've got a lot of automatic, and autonomous? One word, the verb that's italicized there, select. Automatic systems are set up by humans, and then they engage and fire without our further intervention, like an Aegis missile system or a Sea-Whiz on an aircraft carrier. However, autonomous systems select the targets. That verb makes all the difference in the world legally. And whatever selects targets gets a huge amount of legal responsibility for that choice. The whole chain of command does. We'll get to the one poor Japanese general who went the wrong direction. All right. You all know that the key of any information conflict is getting inside an enemy's OODA loop, inside his decision-making loop. You're either trying to move faster than he does, so you're trying to slow him down, or you're trying to inject uncertainty or confusion or something else. And if that's the key to an information conflict, all conflicts are to a greater or lesser extent information conflicts. So having a separate school that does this at the National Defense University, it's good administratively, but we're not a separate discipline. We are in every kind of conflict there is, which is why we have to be so clear about this. So, if you're trying to get into some country's OODA loop, and they can think and fight at the speed of cyber, then even if you're not interested in world domination, even if you just don't want them to be able to do that, you need to be able to keep up with the big guys. So, I came up with this graphic. The bottom end is where we are now, and that's the drone world. A room this size or bigger, lots and lots of screens. If you saw Eye in the Sky, then you've got, Alan Rickman, and you've got all these wonderful movie stars that are going around being lawyers and commanders and planners and making decisions while the drone is safe and invisible and not hurting anyone. And if everyone agrees that it comes back, it comes back. If it strikes, it strikes. And it doesn't do anything faster than we can think. In the red zone, that's the speed of cyber. If we're going to be building autonomous, lethal systems that can fight and think at the speed of cyber, the engagement will be over in a matter of seconds, and dozens of decisions will have to be made, and some of them will be life and death. So for the first time ever, we can't have a collegial thing where Gary is there or Mike is there and just saying, well, here are the tests, here's what you should do, and you can think about it. We have to bake into these systems, if we want them to be autonomous and we want them to have the capacity to cause serious damage, we have to bake in a certain legal understanding of the basic principles of law of armed conflict. And that's going to be a serious challenge for us. Humans are the problem here. I told you about a Japanese general. This is General Yamashita. Actually, he wasn't that bad a guy. He treated British and American POWs pretty humanely. Didn't want to go to war against us in the first place. But once he got the go order, there was some unfortunate stuff against the British Army in Singapore we don't need to dwell on. He's the guy responsible for that. They later put him in charge of the Philippines with all of the atrocities that happened there. He probably really wasn't aware, he certainly didn't order and wasn't aware of them. But when we captured him and tried him, we came up with a new rule. And that rule was the commander not only has to know, but what he should have known. That's what he's responsible for. So that being the case, if we start releasing autonomous lethal agents into the world, what the commander should have known is the standard by which she is going to be judged. So she has to make sure her JAGs can bake into these weapons the tests that will keep the worst war crimes from happening. One last thing in my last minute and a half of talking. These are two humans for which I am proudly partially responsible. In the background, the introvert, John Percival Wingfield, who just began fencing classes, he's a natural, at age 9. In the foreground, always in the foreground, is Catherine Isla Wingfield, age 4, going on 30. And at some point, 11 years in the future, I'm going to have to give her a car. Now, this is the last analogy before we stop for Q&A. In the United States, in most states, when you're 15 years old, you get a learner's permit. And that means you're allowed to drive a car, a potentially lethal instrument, as long as you have a licensed adult right there in the seat next to you. Now, what do? Well, first, you want to buy a safe car. You want her totally Volvoed, so nothing can happen to her. I certainly do, especially for Catherine Isla. You want it to be in good repair. You want to have auto insurance in case the auto gets hurt. You want medical insurance in case the humans get hurt. And then, since you're there with her, you're able to offer advice. Hey, honey, how about not hitting that lamppost? You're able to shout advice, not the pedestrian. And at the end, you can grab the wheel because you're right there. This is what automatic systems are like. When she becomes 16, she becomes a lethal autonomous system. So, you still want... Yeah, that's going to be my girl. You still want to have the safe car in good repair, with good insurance and good health coverage. You want her to have good driver's education. But beyond that, there's no offering advice. There's no shouting advice, and there's certainly no grabbing the wheel. You just have to hope for the best. And that's what capabilities in the next 5 to 10 years, perhaps, will need from us, is to put in whatever we can't do in person so they can think and fight at cyber speed so that we don't turn into the war criminals in cyberspace. So, that is all I have to say right now. Thank you very much. Mike and I are certainly looking forward to your questions. Thank you.